The ethics and future of practicing law remotely. That's the subject of today's ACTEC Trust and Estate Talk.
Welcome to ACTEC Trust and Estate Talk from the American College of Trust and Estate Counsel, a professional society of peer-elected trust and estate lawyers in the United States and around the globe. This series offers professionals best practice advice, insights, and commentary on subjects that affect our profession and clients. And now, our ACTEC Fellow host with today's topic.
This is Travis Hayes, ACTEC Fellow from Naples, Florida. In 2020, the COVID pandemic caused many industries to shift to remote work, including the law profession. According to a poll conducted by the American Bar Association, 87% of lawyers reported that their firm allows remote work. So, what should lawyers and law firms keep in mind as individuals continue to practice remotely? ACTEC Fellows Laura Brown of Seattle, Washington, and Bob Timmerman of Reno, Nevada join us today to discuss this topic and share best practices. Welcome, Laura and Bob.
Hi there, Laura, and welcome, friends and colleagues. It was the pandemic that did teach us that we could work remotely in the legal practice. But I was also a little bit different in that I was also looking at a time of my life when I might want to retire and where I might want to work from. So although my office is located in Silicon Valley, my wife and I moved to Reno, Nevada about 2 years ago, and I have been practicing remotely in a different jurisdiction from where I'm licensed. It's a quality of life issue for me. I like being outdoors and hiking, but I wanted to make sure that the ethics of what I was doing was still appropriate. Laura, how about your practice?
Thanks, Bob. I started working from my home before COVID, basically for quality of life issues, because I was spending too much time commuting, primarily, and finding that I could just consolidate my client meetings to a few days a week and have to go downtown. And then, as we all found out during COVID, I found out you could actually do this from home or anywhere else. So my practice is more of a nomadic. I do work downtown once a week, but I work primarily from my house, or of course when we're traveling, as many of us do, to conferences or on vacation. So yes, we're talking about how to make sure we don't run into trouble if you decide to engage in a hybrid practice or a purely virtual practice. And for attorneys, there are, of course, two issues we have to worry about. If we're licensed in a state, we have the rules of professional conduct that tell us how we must engage ourselves. And if we're in a state in which we are not licensed to practice law, then we're not actually lawyers there, but we have to worry about the Uniform Practice of Law rules. And we're going to talk about those separately.
And, we can start out with, can you work remotely? Well, the short answer is absolutely yes. You are allowed to work remotely, ethically. ABA Opinion 498 governs that. But you still have the same duties and responsibilities that you would have if you weren't working remotely, such as confidentiality. Let me just mention, we must still maintain client confidentiality anytime we're working remotely. And that means you should have a separate area of your home, if you're working out of your home, that is, virtually soundproof. So my wife can't hear me down the hall. I've actually installed aircraft insulation on my doors, and I've put in some soundproofing in the office just to help maintain that confidentiality. What about our duty of communication, Laura?
Yeah, but I was going to also mention we have a duty of supervision for our staff too, who might be working remotely, and making sure that we engage them in the same conversations about who's in the room when you're on the phone with a client or something, because the supervision is also an ethical responsibility. But communication, not much different from when we were in the office. Make sure I think the difference is if you're working Tuesday, Wednesday, Thursday, and you've got a client calling you Thursday evening, they should know you're not going to respond to them until Tuesday. So whether that's an out of office reply saying, I don't work on Fridays and Mondays, or put it on your email responses or in your voicemail. Make sure clients know that when to expect to hear back from you. The other things, again, are same as before COVID. Avoid creating an attorney-client privilege or relationship with non-clients. So whether that's if someone emails you, making sure your email system says, unless we've signed an engagement letter, you're not my client. So the rules are much different than they were before COVID, but I think it's important to realize that if you're working more casually, to remind yourself about those more formal responsibilities.
Sure, and the same goes for your duty of competence. The remote aspect of your duty of competence and also involves technology. You know, you're using Zoom meetings with clients or Teams with clients. Make sure you have cutting edge technology to facilitate those meetings. And the ABA and California issued a formal ethics opinion recently in the last year that competence also includes the mental, emotional, and physical ability reasonably necessary for the performance of legal services. So when you think about it, disasters such as the pandemic, hurricanes, wildfires can have a huge financial impact on the attorney. And that cannot interfere with your duty to your clients. You still have the duty to render competent legal services, and it is not excused by a wildfire. It is not excused by a hurricane. It's not excused. Your remote practice does not alter your ethical duties.
Exactly. I think we could even say your emotional state might be enhanced, however, from a hybrid practice. So that's been my experience. There's also the rule of diligence. Of course, we all must be zealous advocates for our clients. But also, I think it's important that if you're working at home with your shorts and flip-flops on, if you've got a client meeting, I try to dress appropriately from the waist up. If I've got a court hearing, I make sure my dog isn't going to be barking. In Washington, or at least in King County, our court hearings in the probate arena are all still on Zoom. And so I want to make sure I'm in a appropriate location. I don't have stuff going on behind me. I use my blur and all that. So I think we must make sure we're still holding up the decorum and as well as being diligent in representing our clients professionally, even if we're working from the beach.
So that brings us to not just remote work, but what if your remote work is your vacation home in a different jurisdiction? In my case, as Travis introduced us, I now live in Reno, Nevada. I am not licensed in Nevada. I'm only licensed in California. So the next part of our discussion is, can you live in a different state where you're not licensed and still practice law remotely for the clients of the jurisdiction where you are licensed? Laura?
And I think, again, like the earlier question, the short answer is yes, and that's a good news. There are a lot of state opinions talking about if I'm practicing outside the state of Washington, whether I am allowed to do that. And most of a lot of states, I shouldn't say all of them, but many of states have issued advisory opinions on that. The ABA also has a rule, and we'll talk a little bit more about that, but it does say that you can practice outside your state in which you're licensed, so in the host jurisdiction, but you must make sure you're not establishing a law office there if you are not licensed in the host state.
In the Model Rules of Professional Conduct, which have been adopted in every jurisdiction except California, has a Rule 5.5, and specifically it says, a lawyer who is not admitted in a jurisdiction may not establish an office or other systematic and continuous presence in that jurisdiction for the practice of law. So you think, well, wait a second, I have an office in Nevada, and have I established an office, or do I have a continuous presence in Nevada? And Model Rule 5.5, the second part of that says, and I cannot hold out to the public or otherwise represent that the lawyer is admitted to practice law in that jurisdiction. So that's where I feel that I am not violating that rule of professional conduct, because I am not holding out to the public, the citizens of the state of Nevada, that I am licensed in that jurisdiction. Formal Ethics Opinion 495 says a local office is not established within the meaning of the rule by a lawyer working in the local jurisdiction if the lawyer does not hold out to the public an address in the local jurisdiction. So I don't have business card with my Reno address on it. I don't have letterhead with the Reno address on it. Our website says I'm a California licensed attorney. In other words, everything I do as far as the public is concerned represents that I am only licensed to practice in California for my California clients. So Laura, how else can we avoid this continuous and systematic presence that the Model Rule 5.5 discusses?
Well, I think you're right, Bob, that you can't do the things that would obviously look like you're practicing law in Reno. Hang a sign outside your door, say, hey, come on in and see Bob's law firm. Don't have your business cards with your local address. You may have your mail from your California office sent to you or scanned and emailed to you, but generally you wouldn't use a mailing address in Reno for your clients. You also could consider, if you wanted to expand your practice, getting licensed in Nevada, of course. And many states have reciprocity now. But, for those of us who aren't looking to move to another jurisdiction and create more work for ourselves, because Bob, I know you have enough work, that's still a possibility. If you're worried about, wanting to practice or practicing inside your new residence, you might think about getting admitted in the jurisdiction in which you're now living.
Yeah, no, thank you. I have enough to do. I want to spend more time hiking the trails than I do practicing law. So now that we know that you can practice, you should absolutely look up the rules, both in the jurisdiction where you're located, as well as the ethical rules in the jurisdiction where you're licensed, because almost all jurisdictions have some sort of rule or they've addressed this issue of remote practice. In addition to remote practice, we have other practical issues that we almost always have to at least think about when you're practicing remotely. One of those issues might be getting a business license. Do I need to get a business license in Reno, Nevada because I have an office there, even though I don't service any Nevada citizens or clients? I have chosen not to get a business license. To be honest, I haven't even looked into it, but I don't think that just because I haven't looked into it, it doesn't mean that you shouldn't look into it as far as any local city, county, or state requirements. As far as income taxes, yes, I'm in a state now, I'm residing in a state that doesn't have any income tax. California has the highest income tax in the nation. Unfortunately, because it is California sourced income, I am still paying California taxes on the income generated by my practice. Yes, there are ways maybe around that. I'm not about to try and avoid the Franchise Tax Board of California. And then finally, if you do have a virtual office in a separate jurisdiction, Laura said this best, invest in technology. Get the best printers out there. Get better screens. Have 2, maybe 3 screens. Make sure you're working, if you have an IT person, with your technology person in your firm to protect the confidentiality of your cloud-based file system and things of that nature. But bottom line, yes, most of us will at least work remotely sometime in our life. If you're younger than I am, you're probably doing it a lot. But it also allows you to continue to have a practice and to live in a jurisdiction or in an area of your state that has just a different quality of life. I know when I flew down to the Bay Area this weekend, I was stressed by the traffic. I was stressed by the craziness of the drivers that I don't see. So, bottom line, yes, you can and should perhaps consider practicing remotely on a more full-time basis. Laura, any closing comments?
No, I agree, Bob. And the other thing I did right at the beginning of COVID, I will say if you're going to try and work hybrid or remotely, is get everything, all the paper out of your life. Get as much automated as you can, billing, and also files electronic. That's my one biggest tip for the day.
Very good. And if you decide to do it, go for it.
Exactly. Thanks very much.
Thank you, Laura and Bob, for enlightening us on the future of practicing law remotely and the ethics involved with working outside of the office.
Thank you for listening to this episode of ACTEC Trust and Estate Talk, the podcast series about wealth planning matters from the American College of Trust and Estate Counsel. To find an ACTEC lawyer near you, visit actec.org. Please subscribe to this series and leave us a rating or a review.